Hello, my name is Jeff. This is Castle Tutelage, your 2A self-defense law network. What we do is we help people understand the law of self-defense in the simplest terms possible. We take the fear out of getting it wrong. This is one of those questions that happens every once in a while, and I'm just going to readdress it because it will come up every once in a while. And I'll just get right into it. Terry Grossman, just as some make the same argument about modifying your firearms, I've heard multiple times changing to a smoother trigger to place lasers or plain lights on your firearm can be used against you by the prosecutor. At the same time, on another channel called the Yankee Marshal, has said that there's not one case where the shooter was convicted for using such items. Well, I want to address that specific point. The Yankee Marshal, I haven't listened to him for a couple of years, but at one point he said that he was a cartoon character on YouTube, meaning that these weren't his personal philosophies. This is what a cartoon character of the Yankee Marshal would say. Just like in radio, I'm very aware of radio personalities not really meaning what they're saying. They are inciting people for viewerships. So you got to keep that with a grain of salt. The one thing I will say about the Yankee Marshal, he is well informed, he is well read. However, he will use a 6-degree out of phase to make a topic controversial for viewers, for people tuning into him, because that's his thing. Dry, sarcastic humor. That is his thing. Now, I'm going to go through this a little bit because it is a little bit, yes, it's true, and yes, it's not true. He has said in one of his videos a long time ago, and this is, I'm just going off of memory, that no one has ever been convicted of using these certain things, these tools. Well, I don't mean to be disparaging of someone who's people usually say, show me a court case, show me a court case where using these items led to the conviction. Well, I don't mean to be mean to it, but they just don't know how the system actually works and how we can look up things and say this is what happened. Now, at the trial level, the transcripts cost hundreds, sometimes thousands of dollars to read. So therefore, your average researcher is not going to go down to the trial court level to see what happened in the trial and the transcripts. But your main focus is show me a court case where it got you convicted. Well, isn't that in the mind of the jury, the finder of fact? Tell me where there is a resource where it says what the juries were thinking at that particular time. What pushed that juror over the edge towards conviction? Now, having a smoother trigger isn't illegal. So why would you be convicted over something that is legal? Lasers, flash-mounted flashlights on your gun. Those are all legal items. Why would you be convicted over it? Well, it goes toward your intent. It goes toward how you view what these things are. I'm a strong believer in not modifying your trigger for a very specific reason, because if you modify your trigger, if you went to a 3.5 pound pole, what will happen is that you are more likely to have an accidental shooting compared to a 4.5, 5 pound trigger that Glock usually has. Why is this important? Because self-defense, you meant to pull the trigger. That is part of the argument, where an accidental shooting is an accident, where you did not mean to pull the trigger. Now, there are some court cases that the trigger has been modified and it was part of the equation of what the appellate court decision was, because what the appellate court decision judges do is they take the transcripts from the trial level, and they incorporated what was the argument for whatever error occurred in the trial court for the reversal of a decision or a conviction for the appellate court judges. Okay, there was again when you're reading appellate court decisions of self-defense, there's always several items that happen. A boy fighting another boy over a girl because they were drunk and a firearm was involved. Those are the 5 elements that you will most always find in an appellate court decision. There was a court case in Texas where 2 drunk idiots were arguing about an old girlfriend and a current girlfriend, and the old boyfriend went to go get his revolver, and the trigger was modified to something ridiculously small, and he ended up firing it on accident. And I don't remember the disposition with it. Did he? I think that the other person was killed in that. So we have that element, and then we also had a civil trial where in I want to say Tombard, Texas, if that is correct. I'm not sure if that town is correct pronunciation. Where an officer was going after a truck that fit the description of some crime, and he pulled him over, and he was a little bit too excited. He jumped out of his car without fully putting it into park, and he pointed his gun, and the gun went off. Now, no one was hurt in that situation, but that was a civil trial where they were trying to get money out of him. Well, the reason why I'm saying this is because it was found later in discovery that the officer's Glock had a modified trigger in it. These are the questions where if you do have a modified trigger and something goes wrong, you didn't mean to shoot it off, or your hand, like this officer, he got out of the car, his hand bumped the car door, and it went bang. Is it less likely to go bang with the 6-pound trigger pull than, I forget, was a 4.2-pound trigger pull for the Glock? I don't remember the specifics on it. It's been too long. That is why I'm very hesitant on trigger pull. Now, when I first started reading a lot of court cases, I came over this trial court case, and the prosecutor asked the gun expert 2 questions. One of which was, the guy changed his sights on his Glock. Well, everyone changes the gun sights on the Glock. And the prosecutor asked the gun expert, why would you change a gun sight on your gun? The gun expert looked at him and says, because it makes it easier to shoot and kill people. All right? The other thing was the slide release. The slide release on the Glocks are, kind of bad, so this guy also changed the slide release. And the prosecutor goes, why would you change a slide release on a Glock? And the gun expert looks at the prosecution, and he said, it makes it easier and quicker to reload your gun to kill and shoot people. Now, the gun expert can say anything they want, but it really goes toward why you changed it, what is the perception of why you changed it, and how the jury perceives you if you wanted to get into use of force event. Now that brings me all the way to this. Kyle Sweet, a long time ago, and I played his video of what he doesn't want to see on a gun. Basically what he wants to see is it closely mimicking police departments, because it is already deemed reasonable to have some kind of a police style setup. If it's outside the guise of a police setup, you could be putting yourself into jeopardy for some reason. Like me, I'm a big fan of not having colored guns. Make it black, and just go from there. You girls that have these pink and mauve and all these other colors, someday it may end up where the prosecutor is saying, hey, this girl is putting jewelry on the gun. They are glorifying it. It's kind of like putting a notch in the wild, wild west of how many people you killed. So it goes to perception. I want to talk about safeties for real quick. I would never change a safety on a gun, because then it becomes the fact of that you know better than the manufacturer and how that gun should operate. Where did you get your engineering degree? Why did you change or modify the safety? The big thing is a thumb safety. Why did you change it? Now, if another model of that same manufacturer has a DASA kind of a situation, or you can modify it into a safety situation, then you can kind of talk around that problem. But those are the certain things that you're looking for. So the people who are saying, show me a court case where it was convicted. Well, we don't know what's going on in the mind of the jury. We don't have access to that. It's all about perception. Having the Punisher plate, the Punisher on the back plate of a Glock, I wouldn't do it. I wouldn't have a logo on it. I wouldn't put anything on it. That cop down in Arizona with the saying on his AR-15, I forgot what the saying was. He was convicted, and then it went to the appellate court, and the appellate court reversed the decision of the conviction. But I think the only reason why that case ever went to trial is because of that stupid saying on the side of his AR-15. I can't remember what it is. Would the prosecution have gone to trial without that saying? I don't know. Masad Ayub, about 10 years ago, wrote an article about a hiker in Colorado coming across a deranged man and shot and killed him. And the prosecution had a problem because of the school that he attended had one of those macho sayings. Again, it's been too long, I don't remember it. But my impression is this. I'm not a big fan of having a weapon mount light on your carry gun. You have to have a specialized holster. The training could be overwhelming for the average person, especially with the 2-finger operation or 1-finger operation of controlling that. You can get your fingers confused. It has happened in Colorado. About 5 years ago, Colorado was actually thinking about outlawing police from having weapon-mounted lights because they were doing stupid things with it. Some officers, and this is coming from the police chief, I think from Denver, went out and watched his officers pull over people. And what they were doing is they were taking their gun out of the holster and using the light to shine on the license of the person that they pull over. That's a police application. For civilians, are you going to be taking out your handgun and using your light to go look for something? No, because you should only be taking that gun out unless you're in immediate threat of death or great bodily harm. I have no problem with having a secondary light as your primary light and using the weapons model light as the final identification and go. Those are the types of scenarios where you're looking at modifying a gun, modifying the sights, the color, the grip, the springs inside, that kind of thing. If you do anything that makes the gun more unsafe, well, you may have a problem with it. One thing Yankee Marshall said a long time: if it's a good shoot, it's a good shoot. I agree with that. If it's a good shoot, it won't matter what color your gun is. It won't matter your trigger pull. It won't matter what sights, what grips, or whatever little trinkets or sayings that you have on it. But it will come into question if you don't do everything 100% correct. If you are in a use of force event, are you going to do everything 100% correct? If you don't do everything 100% correct, but you have the temperament and the mentality and the persona that you were in fear for your life for great bodily harm, and you went after it in that vein, not I wanted to get in a use of force event. Look at all my cool, tactical kind of situations on the gun that make come into question. So when you are listening to these people where that kind of things, those kind of items don't matter, I would disagree. There are a lot of manufacturers out there that have better trigger pulls than a Glock. All right. I use the CZ-P10. I think that is the best out-of-the-box gun, striker-fire gun that is out there right now. And that's my personal opinion. I've been running with that gun now for almost 2 years now, and I'm excited that the CZ-P10 full-size gun should be coming up here soon. I'm excited for that thing to come out. So in conclusion, when you hear people tell you that it doesn't matter on certain things, you're right. It doesn't matter until it matters. You have control of what you put on the gun, but you don't have control of what the jury is going to see and what your intent is if you ever are in a use of force event. All right? So when you hear people, show me a court case, they're ignorant in how exactly what it is. It's not against the law to modify your gun. It isn't. Why are you going to be convicted for doing that? Well, what you are going to do, it may present a problem for that soccer mom who's never fired a gun before. What happens if you shot and killed a 16-year-old child who was going after you and who was on bath salts? And you're going to get an anal probing anyway. Remember, I've talked to you. There are several thumbs down factors where you're going to get an anal probing about your self-defense event, and shooting a minor is one of them. Okay, they're going to start looking into your Facebook page, your bumper stickers, your guns, your trinkets, the modifications on that. They want to make sure, since it is a minor that you have shot and killed before they have attempted to shoot and kill you, whatever the situation is going to be. They want to make sure that everything was above board here. And that's just the way it is with that thumb down situation going against a minor. All right. My name is Jeff. This is 2A Self-Defense Law. I hope this helped.